It's Lisa from Been There, Got Out. Today's guest, New York divorce attorney slash family lawyer, Dennis Vetrano. And he is, let me see if he's figured out how to get on here yet. There he is. You did it.
Hi.
We have the same wall, but I'm not in our little studio. We have the same bricks.
I figured I'd change it up a little bit today, you know?
Yeah. Yeah. It would have been cool if we matched, but that's okay. It's about content, not
Right.
Right. So Dennis, I was saying that it's been a while. It's been like almost a year since you were on with us or with me. Chris is not allowed on these interviews because we all talk too much. So it's too much New York energy. So can't do it now. But thanks for coming.
Poor Chris.
What?
He's been banned? Poor Chris.
He's not banned. He had his turn a couple of days ago on another podcast. And we were just on your podcast together, which, we don't usually come on together. So he had his time. Now it's going to be just us. And for people who haven't seen you here, there he is. He said hello. So he's watching. He gets to watch and comment. He'll manage the chat. But anyway, so Dennis, for people who haven't seen you here before or don't know who you are, I don't know how they couldn't know who you are. But if they don't, you want to just introduce yourself.
Yeah, Dennis Vetrano. I'm a New York divorce lawyer. I got a bunch of stuff on Instagram and TikTok and stuff like that. So.
Yep.
Although I don't like talking about divorce. I don't like talking about divorce law necessarily. A lot of times I like talking about like the mental, emotional, relationships, sort of logistical, nuts and bolts sort of pieces of it. Because I think lawyers don't focus on that enough, and we have something to offer there.
Yeah.
So.
Yeah, but I'm going to tap you for something that we talk about often, and that's stuff regarding kids stuck in high conflict custody situations.
Yep.
And so what I also love that many people might not realize is that you have domestic violence training. People always complain that lawyers have no background, they don't get it, but you're one of the lawyers that does get it, and you have the training. So you're not just, you are aware of a lot of those issues that many people are not. All right, so let's start with the idea of something we talked about in the past, and Chris and I talk about too, is that people often believe that it's best to stay together for the sake of the kids. But we know that sometimes staying can be harmful, even when there's not like obvious, let's say, physical abuse. So can you talk about what you've seen, like maybe situations, because you are a divorce attorney, like when it is better to get a divorce? I know you're talking about when people should maybe stay together lately, but when do you know like this is not a good idea? There's signs.
I think it's part of it's part of the conversation. Really, either way, I think, and it's a tough decision to make whether or not to split. I mean, I think, look, I start with the core, right? I start with what I consider like people problems. Forgive the expression. I know I'm oversimplifying. But if you have something that's an individual problem that somebody has that you as the partner really can't fix, they need to fix it on their own, and they're really not working at fixing it, those are the situations you need to get out. So what do I mean when I say people problems? I mean major substance abuse issues. I mean major domestic violence issues. I mean major mental health issues. You can't fix your partner if they have that. You can't be the fixer. They have to, forgive the expression, I know it's oversimplifying again, they need to fix themselves. They need to get that sorted out before you can be with them. Because if you're with that person and the kids are in that circumstance, that toxic relationship is so much more damaging than any split, peaceful relationship could possibly be. I mean, even the co-parenting that can be really difficult after the split is nowhere near the kids being within the acrimony that's taking place each and every day.
Right, because it's normalizing that kind of relationship, and we're often drawn to what's familiar, and many times kids will repeat the cycle.
You're modeling for your kids each and every day, whether you realize it or not, the behaviors you want them to espouse, the behaviors you want to see them exhibit. You're teaching them every day. Every little thing you say and do, they're watching and they're learning. So if they're seeing that that's what a healthy relationship is supposed to look like, because that's what they think, as they get older, they'll accept that. So for example, if my daughter watches daddy beating up mommy, When she gets older, she's going to think that that's acceptable. She's going to think that's okay. The way I treat her mother is the way she's going to expect men will treat her moving forward. So if I don't model respect and admiration and, anything you want, I pick my daughter specifically, but anything I want her to demand from a partner as she gets older, if you want them to demand that as they get older, you need to model it in your current relationship, everything they see.
Yeah, I mean, sometimes we see parents saying that, well, they say, I tell my kids, don't act like mommy and daddy. Don't do that.
Right. Do as I say, not as I do, sort of thing, right? But that
Yeah.
doesn't work. I mean,
Yeah.
kids are sponges. They like soak everything. While it's so funny because on the one hand, and I used to represent children. I represented, hundreds, thousands of children because I did it for like 12 years, and I had a lot of cases over the 12-year
I
span.
don't think I knew that, Dennis.
Yeah, no,
Wow.
I represented kids for a long time. Substance abuse addicted kids. So I did drug court. I was a attorney on the drug court for a couple of different counties, and I prosecuted child abuse and neglect for a period of time. So I spent a lot of time around kids, varying different situations. But yeah, they soak everything up. So on the one hand, they're very resilient, but on the other hand, they're soaking everything up. And a lot of times you got to be careful, whatever situation they're in, because they're internalizing, right? So, you always have to be mindful as you're going through this process. And especially if you're in a toxic relationship or situation, you really need to be like super keen and in tune with your kid to know if there's any, like, what's the baseline there, right? Because what fluctuations in behavior are you seeing? Because if you're seeing your kid like acting out or having tantrums or not sleeping well or not engaging, withdrawing socially, you need to know that it's time to get them involved with a counselor. So,
Yeah. So speaking of that, that's one of the things that we see in our community that's very hard sometimes is that when a couple splits up, one parent says, the kid is fine. The kid is fine. They don't need therapy. They don't need help. Everything's good. I don't want the kid to have therapy. And the other parent, often our client, is going, what are you talking about? There's suicidal ideation.
Yeah.
They've been expelled from school. Like, how can you ignore it? Have you seen situations like that too, where one parent is almost like, nope, it's fine. No therapy.
All the time.
What tends to
and
happen?
I think all the time. And I think in these cases, what I'm trying to do is I'm trying to keep the acrimony down in the divorce cases and the custody and visitation litigation cases. I'm trying to keep the litigation down. But in those sorts of circumstances, if the other party is not consenting to that and doesn't want to proverbially play ball with that, you need to get a judge involved and have an attorney appointed for those kids to represent them and say, hey, it's funny. I was reading an article the other day. I've had some health issues here and there recently. And one of the articles, so what do you do? What do you do? You're feverishly like Googling and looking things up and what they said is statistically, women typically do better with this particular illness I was researching than men. And they believe in part because the men will not go and get help. They'll ignore it and let it go. So that dynamic is generally what I see with kids with counselors. Dad saying they don't need a counselor. What do they need a counselor for? A counselor is something you really don't need, and the wife being like, again, and it does happen on the other side. I get it, but that's generally what I see. And then the wife being like, but oh my God, why don't we at least just like give it a shot and just make sure if there's something out there, we're dealing with it, because you don't want a situation where, the child is having mental, illness things that they're wrangling with, or suicide or suicidal ideation or running away, or, you want to cut that off at the pass for sure.
Right. And most judges will push for, not push for it. They will agree if one parent asks for therapy generally, right?
I think, look at it like this. Sometimes they will and sometimes they won't. They generally, more likely than not they will. But if you have an attorney representing the kids who's saying it's a good idea, now you got like that proverbial math problem, like you got 2 versus 1. So the judge is probably gonna, even if they don't necessarily believe in counseling, though, they're likely to acquiesce.
Yeah. Well, that's good. Okay. So we often talk about co-parenting with a narcissist or co-parenting with a toxic person and how difficult it is to do. And something you had said a while ago is the reality you have is no alternative. You have no alternative. You can't just check out. Can you talk a little more about like why failure to communicate with a co-parent, even if it's a counter-parent, even if you're parallel parenting, how it can harm you if you just check out and say, I'm not going to deal with that person. It's my
Yeah,
kid.
I think in these sorts of situations, it's so difficult for people. That's why I wish people were working with coaches more frequently, because it's so hard for the layperson to distinguish, okay, what is something I need to engage with and respond to, and what are things that I don't. So generally, and probably a good rule of thumb baseline is when they send you something that has a lot of adjectives involved, like you're the this, you're the blankety blank blank blank, and this is this way because you're the blank blank blank, and you're the blank blank, whereas you got to get all the adjectives out of what they said to you and see if there's anything substantive. If there's something
I'm
substantive,
writing this down.
if
Love
there's
it.
something substantive, respond. So, you're the reason why they can't go to soccer camp, and the soccer camp's across town because of now really all their only question was, when's soccer camp on Thursday? So your response should be vanilla, straight to the point, don't engage. Soccer camp's Thursday at 8.
Yep.
That's it. And if they keep on and on and on and on, and you've already answered the substantive question, you don't need to answer anything else.
Right.
But I think it's also important to make sure any court order or any parenting plan is clear on what your expectations are from each side and what the requirements are, because you don't want them to say, hey, you were supposed to respond to me, you were supposed to do X and Y and Z, and you didn't. So for example, you have those parents that, like, we always get the parental pride parents, I call them, where they say, I'm entitled to 50-50. I'm the father, I'm the mother, I get 50-50 automatically. No, you don't. When it's a split family, you get whatever the judge believes is in the best interest of the kids. And usually it's some level of commensurate with the engagement you had with the kids throughout, right? But they want to walk in and say, I want to be half parent. And in the next breath tell you, but if there's a school schedule, you've got to give it to me. Or if there's doctor's appointments, you've got to figure it out. No. When you arrive at your parenting plan, say, here's the doctor, you can contact them yourself. Here's the school, here's the website, you can get that stuff. So now, so when you finish your order, you get something in your order that says, they're going to, usually they'll exchange information or be provided, but you also need to be clean with the language and say, hey, they can get it themselves, let them get it themselves. If they want to be engaged as a parent, yes, engage, but then you have a responsibility with that. Then it's like you need to contact the coach and know when soccer practice is or if it's canceled, right? Then you need to contact the dentist and say, hey, when's the next dental appointment? When do I need to schedule it? Or when's the next physical for the pediatrician? So yeah, it's important to be clear on what your responsibilities are in your parenting plan or your underlying order. And then once you do that, respond to the substantive things and not the hyperbole, as I call it, because you don't have to. But just make sure you're doing what you're required to do under the order. Because a lot of times what they want to do is, toxic people, they want to reel you into a problematic situation. They want to keep sending you these hyperbolic messages that you're either going to respond in kind with, number one, which can be damaging if the judge ever reads those, or number two, you're not going to respond to the substantive things. And then they can go, I got you.
Yeah.
Now when we go to court, I'm going to show all these things to the judge. So yeah, respond to the substantive things that you need to, not the things you don't, but be clear cut about what your responsibilities are.
Okay, so I want you to clarify something that I want to make sure I'm not misinterpreting. A lot of people have been saying, well, I'm really worried because my order says that I have to respond to we have to respond to messages within 24 hours.
Right.
And I'm like, yeah, that doesn't mean every single message, because we know that the other side is going to harass and torture you about messages like the ones you just said with lots of adjectives. The judge doesn't mean that you have to respond to every single message within 24 hours, correct?
If that's what the order reads, now you've got a problem. So let's rewind a little bit. You should be talking with your lawyer about what the obligations are under the order. If you have an order that says respond in 24 hours, that's what it means. If it's something that's not a substantive message, then I guess yes. If they're cursing you out, do you need to respond to that? Or you've already provided the information? Not necessarily. But again, I think the best thing you can do is let them keep trying to reel you in. Because what drives the toxic person completely nuts is not engaging with their BS, right? So think of every message you send back as a message that the judge is going to read in open court, or it's going to be read in open court. Think about everything you write could end up at the courthouse. So they send you this hyperbolic message, soccer practice at Thursday at 8.
Yep.
On. You already responded.
Yeah. Like what you said about the judge, we always say to our clients, you're writing to your ex, but you're writing for a judge. You always plan that this is going to be part of an exhibit in court. It's going to be those patterns of behavior over time, not just theirs, but yours too. So everything that goes out, you need to think about, carefully consider. Like we put our clients, I used to be a high school English teacher. So we put our clients on the permission slip plan. We say you are not allowed to send anything if they haven't passed the stage yet. Right. You're not allowed to send anything. You have to send it to us. We got to just check it and make sure it's okay, and then you can send it. And that means you have to wait to get an answer. Right. So some people fail a little bit on the permission slip plan because they're just like, I have to, but it helps calm things down a little bit because they know there's other eyes on it. And then also some of them use it just to vent, where it's like, here's my draft, and I'm like, we both know you're never going to send that, but you got it out. It's good to get it out. But not to the other person where it's going to turn into what kind of evidence later on of your
I even do
poor
that as a lawyer.
Control.
I even do that as a lawyer. I did that just the other day. I wrote a letter to the court responding to a letter that this opposing counsel wrote, and then I proofread it and took a couple sentences out. But that's what you're supposed to do. I mean, you just have to be very measured. It's funny. I can remember a case that I had years ago representing 2 children, and there was 27 petitions filed in that particular case. I want to say in 6 months or so. It was insane, and the case had been pending for years. It actually went to the appellate division, everything else. The only way I was really able to, because remember, toxic people can be elusive. They can be so, if you don't know them, they can get over on even the most astute people.
And they
love
it.
Right.
They love it.
Right.
Because that's a win.
I was only able to ascertain the reality of this case by sifting through and reading line by line a box of emails. A banker's box of emails back and forth. Because you'd be surprised, leaving people to their own devices when they have communications between the 2 parents, that's the best way to really discern who's doing what in the situation. Not because when they see you, they're going to smile and shake your hand. And they see the school officials, they're going to do the same thing. In court, they're going to have that Cheshire cat sort of grin on their face, like, what, me? Sort of thing, So again, they can be very deceptive, let's say. So you really just need to sort it out. But I think, again, if you get to that situation where the court is going to look at those emails, and many times they are, especially if you have a litigated case, they're going to read them and they're going to see what you're doing. And even if you don't mean to, if you're not taking the high road the whole way through, and I tell clients, I don't care, swallow your pride, take the high road the whole way, don't engage. Let them just keep doing their bullshit, because, that's...
We'll take the high road in the communications that you send to them, but you can still get it out. Get it out, talk to your friends, journal, whatever you have to do, but
get a support
send it.
System and a sounding board, and maybe a journal. That's a good idea. But don't put any pen to paper on anything that they could put before a court.
Yep, exactly. All right, so what about, there's also something that we know is a myth, and that's that once things settle down, the default is amicable co-parenting. So something must be wrong with me, because why isn't my parenting situation like this fantasy that I think everybody else has? Do you see that? Do you see that most people get along great once things calm down a little bit? Because I don't. In our world, it gets worse.
There's a quote that I'll refer to. It's a people going through the divorce process are 2 to 3 personalities away from their normal baseline personality when they're going through the process. So
interesting.
I think that's right. I can't remember where I read that, but I think that's totally 100%. And I know from even just dealing with the clients, they'll be screaming in the office, and then you'll see them on the street 6 months later, and it's totally different person once they're out of the process. So there is that. There is a shift once you're out of the process. However, I also tell clients, I can do anything you want with your court case within the bounds of the law, but I can't change the other person. You know, there's a reason why you left that person. There's a reason why you're not in a relationship or not married with them anymore or married to them anymore. So I think just keep in mind that you will have to deal with this person. You cannot change them, and you will need to use your tools and find ways to appropriately cope with this person. So, and I think maybe as I'm thinking about it now, if the earlier you accept that, the better you will be moving forward. Understanding, hey, this person's a jackass. I can't change them. They're going to be who they're going to be. I just need to, cope and deal with it.
Right. And also, when you were saying about they want you, the lawyer, to fix or change the person, I think many of our clients in particular expect to go into court and they want the judge to order the person to change, and they want the judge to validate and say, they're wrong, I'm going to punish that person for being such a jackass.
Right. People think that when they go to the courthouse, they will find the following: justice, fairness. The family court will believe them automatically, see it their way, and rule in their favor. Virtually every single client I've ever had believes all of those things when they walk into the office. And I try to tell them the courthouse is not the place to go to find that. You will not find that there. I wish you could. They don't have the time. They don't have the resources. They don't have the training. So it's difficult situations. So
yeah, it is. Okay, another thing that people make the mistake of is, they think that everybody's going to do including their ex, is going to do what's best for the kids. But sometimes people, even our clients and us ourselves, we do things that we think are good for our kids in these difficult situations, and they're not.
Yep.
I have an example that we talked about last time, but I want to hear what your thoughts on things that you have seen that maybe someone's like shooting themselves in the foot, not just in court, but in life, where they're not handling things as well for their kids as they should be.
Yeah, I mean, I think honestly, right now, with everything involved with kids, I think that's one of our biggest problems. We as adults are trying to determine what's best for our kids, right? And for many people, that's not problematic. They really just want what's best for the children. But I think to a certain degree, you really just need to rely on your resources, some experts to work with, some counselors, and really just knowing your kid. I mean, to know what's best for your kid, how about you ask your kid? Like, how about you engage with your kid? How about you know your kid?
Right.
So I know for my kid, like let's say, for example, I'll give you a perfect example with soccer, right? He's a very competitive kid. A lot of the other kids like can take or leave, like, I'm just out there to play. I'm just out there to knock the ball out. I know he's competitive. And I know that by being around him a lot and watching him play and coaching him and everything else. So, I'm going to put him in situations where he can get that level of competition because he enjoys it. He appreciates it. Whereas there's a lot of leagues who would say, well, it's not about competition. It's just about participation, blah, blah, blah. Now, I know that they're doing that based on what they think is right as the adult. But at the end of the day, it's about knowing what your kid wants, what's best for your kid. And it's funny because kids become bargaining chips in these cases often. And I think that's probably what you're getting at more than anything else. And I think that's, again, I come back to the example of the parent that was just never really involved. And now, all of a sudden, like, wants to be parent of the year and insists on a 50-50 situation when necessarily that's not really what's, necessarily best for the child. Does that mean if you weren't super involved during the marriage, that once the marriage splits or once the relationship splits, that then you get nothing? No, I'm not saying that. But I think the relationship, the rapport, the connection with your kid needs to be earned. You need to work at it. And it can't be, I want this just because I can, or just because I can argue, or just because I'm mom, or just because I'm dad. It's because you've worked to develop that relationship and deserve that.
Not just the last few months that you've started litigation.
Right. And there's an interesting piece to that. I just did a podcast with Rob from WTF Divorce, which I thought was an interesting interview because he said, look, after he split, he was like, here I am with like, you know, the kids. And like, now I'm like, there's an earache or I'm not used to dealing with this because mom always took over, you know, and not necessarily because he needed her to take over, but because mom was like, hey, I'm going to take over on mom. And I totally get it. I'm not faulting anybody, but I think you got to look at it like this. If you're in that situation as that parent who wasn't super, super engaged during the relationship, and now you're kind of, okay, you've asked for as much time as you could get because you know you want to do it, but now it's time to engage and to learn. Like, you build. So now, you know, even when you're in the relationship now, it's funny. I can remember when we first had my two kids and I was a little nervous. I was a little scared. Mom was taking over everything, you know, in large part because she had to and because she's a good mom. But like, I started to occur to me like, hey, whoa, wait a second. I can handle this. I can do this. I can go to the grocery store with like a 2-year-old and a 3-year-old and manage it. Or go, I can do this. I had to just like conjure up this inner strength of believing in yourself well enough to know. But I didn't want to, you know, for me, like in part being a divorce lawyer and also in part because I'm engaged with my kids and I love them and I want to be a good dad. I said, this has got to be a time for a shift. She's got to get a break, number one. And number two, I've got to do more. I can do it if I want to. And I'm going to figure it out just like mom did. I have to figure it out. I can't just, you know, say, oh, it's too scary. I don't want to do it. Let mom take over. You know,
Right.
The thing.
Yeah, because that's a dynamic. Who wants to keep that dynamic? Well, some people do. But.
Right. And he was talking about that. I thought that was really interesting. I think that's a dynamic we don't talk about enough, especially with dads, you know, like get in there and believe in yourself and you can figure it out if you want to.
Yeah. I was thinking about before when some parents use their kids as confidants.
Yeah.
Yeah.
Well, that's something I would consider like parentifying the kids, right? It's funny because we had a conversation with our kids the other day about like, you know, like we talked about my Lyme disease thing and all other stuff, right? And he's talking about like, what do you share with the kids, right? Because I can remember having child abuse and neglect cases where you have the parents coming home and like telling their kids about how they can't pay the rent and how they have a drug problem. And it's not like, kids don't need to hear that.
Right. That's
2, 3, 4, 5, 6
that's
years
not the connection with the kids that we were talking
That's not what you want. But to be fair, you also want to develop that rapport, that relationship, that connection with your kids. So how do you like find that balance where like you're having those communications with your client, but you're not talking about adult issues with the kids? You're certainly not saying, hey, tell your father when we have contact next week, he can't, or here's the child support check, right? I mean, clearly those things are like not things you want to do, but by the same token, you know, you do want to like share things with your kids and hope that they share things back.
Yeah. So what you just mentioned, I think that comes up often in our world where people say, my ex is oversharing all kinds of stuff about our court things. Our decree says we're not allowed to talk about court with the kids, and they're doing it. So I'm going to go back and try to get custody. What do you think?
That can be a hot button issue, but I don't see a court changing an order wholesale on that alone. But I do see trying to get a court order that, you know, forbids them from doing that. And again, what's the value of that court order? Who the hell?
Right. Like, what's the enforcement? What are they going to do?
I mean, here's the thing with family court. You got to remember, like I explain to clients, what I do as a lawyer is I get you pieces of paper. That's what I fight for. Pieces of paper from a court that tells somebody to do something or refrain from doing something. At the end of the day, it's still a piece of paper. It's a court order, it's enforceable, but it's even like, for example, a domestic violence relationship. Stop, I've got this piece of paper here. I get it. There's a lot of like authority and implications that come with that piece of paper, but at the end of the day, it's still a piece of paper. So I think what you have to try to do is, so what's the answer to that? It's a difficult question. What's the answer? The answer is you have to just like work behind the scenes with the logistical things, right? So like if your kid is being, you know, so let's say brainwashed by the other parent and talking about the court appearances, that's a situation where you definitely want a professional involved with the child, just so they can try to like stay grounded through the process as much as you can. And I know, well, okay, what's a counselor going to do? They're not necessarily going to get them to stop talking about the court proceedings, but they at least will help your kid mentally and emotionally kind of like get through it. And somebody independent, right?
Yeah, yeah. I mean, that makes sense, but I'm glad that you noted that that's not the kind of thing that a court's really like. They say things to hope that people will listen to it, but then there are things that are not actually enforceable.
Yeah.
Like, let's say, for example, the right of first refusal.
Right.
So it's in the agreement. It's in a lot of agreements, but in our experience, we've been told that's not actually that enforceable. If you go to court and say they had a babysitter instead of asking me first, and now they're going to get right, nothing happens.
You have to look at these cases like they're large issues. Think of it like this. Every family court judge, virtually everyone I've been before, has literally hundreds of cases. And they're back to back, 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 back. I tell clients, you are lucky, because I prepare my cases to make arguments, obviously, as lawyers should when they go into court. You are lucky if you have a minute to 2 minutes of that judge's attention. And even if they allow you to talk for more than a minute or 2 minutes, they're probably not listening for the last 2 or 3 minutes, even if you continue to drone on, right? So you really just have to focus on what are the big things, what are the most important things. So if you have a client that, say, for example, has a great custodial arrangement, they have the bulk of the time with the children, they're in the driver's seat for extracurricular activities and school decisions and stuff like that, and they're really comfortable with that order, going back to court saying they're talking to the kids about this or that, going back to court saying, because remember, with these cases, they're so wonky, you could file a petition saying they're violating all these little tangentially related things, and they could turn around and say, oh, okay, that's great. I want custody. And you end up in a
Right. I
custody
call it
trial.
opening the can of
Right. You
worms. You're
end up in a
opening the
custody
can of worms.
trial.
Right.
So I'm just like, if they're doing little stupid things, like you just have to be very cautious about when you want to go to your lawyer's office, pay your lawyer, go back into court, file another petition to get back in before the judge, because you just never know. I remember these cases that I've had where the person was, substance abuse addicted and not engaging in treatment. And they wanted to file a petition saying they're not engaging in treatment, but they weren't having that much contact anyhow and already had supervised visits. So now you go back in saying, hey, we should suspend the visits. And they turn around and say, oh, look, I got a certificate. I'm completed. Now I want every other weekend. The court was like, what happened? Like they weren't doing treatment. Like they weren't engaged.
Yep.
But now they turn around and they're engaged. And the judge is like, well, look, they got a certificate. Like, because a lot of times the judges are going to go path of least resistance. So path of least resistance is we've got a certificate. They were supposed to have visitation. Now we give them there every other weekend. Now I get you out of my hair. And the case is gone. I know that sounds terrible, but.
Yeah, no. And what you said before, I jotted down a little note about having so little time before the judge. We often tell our clients, imagine it's the Super Bowl and you're paying $1 million. You get 30 seconds.
Yeah.
That's what it's like in court. You get 30 seconds, maybe a minute. You need to stay focused on what the issue is.
Right.
If it's a custody issue, don't talk about how bad they abused you, because that probably doesn't impact, it does impact the kids, but that you have to be able to show how it impacts the kids if it's a custody issue. It's not a restraining order is a separate thing, but people tend to blend the two. Right. Do you see that as well?
Yeah, for sure. And it's even today, like it's, you'll tell a client, okay, I need to get some explanations of this petition so we can make arguments when we go to court. And 9 times out of 10, I'm getting 30 pages of something that has everything under the sun. And I'm thinking like, I can't, like what? So then usually what I'll do to be cost effective is I'll give it to my senior paralegal and say, look, can you boil this down to the Reader's Digest version for me? So I'm not charging X amount of dollars an hour to do that on my own before I go into court. But yes, time is super, super precious before the judge. And I think the judges appreciate if you walk in and say, hey, we have the petition. We know what it is, Judge. We're not going to bring up all the issues for trial today, but here are the things we need to address today. Here's what's most important for today, if you do. And if you don't need to address anything that day, maybe you're better off trying to get in and get out of court, So
right. That's what they want anyway.
Correct. They
in
want
and
to
out.
see,
That's why you always
that you appreciate
media.
their time, that you respect the proceedings, that you know the law, and you know what's important and what's not important.
Yeah, exactly. And what you talked about with getting 30-page things, that's one of the things we focus on with our clients. We say we don't want you to throw everything over the fence to your attorney because it's expensive.
Right.
So yeah.
Here's what happened last week. Here's what happened last month. Here's the kitchen sink. here's my wedding dishes. Here's like, no. What's most important today, tomorrow, the next day?
Yeah, I was actually talking to a Connecticut divorce attorney in person, and I said, what makes your perfect client? What kind of clients do you love? He said, I love clients who are the opposite of me. I love when they come in and they're super organized,
Yeah.
and they have charts and they have summaries and everything is ready. And I'm like, that's what we do for clients. Like, we help get them ready for people like you, Dennis, so you don't have to deal with the huge mess. And we do a lot of the hand holding that luckily you could do, but they'd be paying you a lot more money for.
We usually try to do engagement letters, which will kind of like keep it, it's funny, you talked about it the other day in our office meeting, to do engagement letters in every case, just to keep people focused. Here's what I need, this, that. And the letter doesn't end up costing you that much as a client, but it keeps you focused, right? It's so, these are the things that I need to provide. Now, 9 times out of 10, you're still going to get 30 pages of something, which
I was going to say, but many of our people, they're traumatized. They're like, I'm not even reading. I'm still going to give you this because I want you to know, because you need to tell the judge all this stuff, right?
Right. Well, yeah, the difference between wanting me to know and needing to tell the judge, that's a very important distinction there. I want to know. I'm not necessarily going to tell the judge all that stuff because it's not, we're there to translate all of your raw data, all your raw information into something that the judge will likely understand and click with them and they'll appreciate.
Right.
Okay. So you're going to come in with a boatload of information. And then we're going to say, hey, here's the stuff you gave us, right? Here's the stuff you gave us. Actually, more like this. Here's the stuff you gave us, but here's what the judge really needs to hear. This scenario. Now, maybe at trial, it becomes more expansive depending upon how complex the case is, but.
Yeah, that's why it's so important to have educational conversations so people understand this is the stuff that the judge cares about and this stuff he or she does not care about. So it doesn't mean that it doesn't matter. It doesn't mean that it's not important, but it's not something that's going to matter in that court setting. I think we have to keep saying that over and over again because people are leading with emotion and court is obviously not the place for it.
Well, I mean, think of it like this. This is their life. This is their life. So even an example, when I go in to see a doctor and I have an issue, right, I'm going to give them a stack of stuff of all my symptoms, and they're going to parse out what's important and what's not important. And a lot of it is going to be, especially for these cases, when it comes to the most important things in their lives, you're going to get a whole lot of information that isn't necessarily relevant. So for them, it's their life. For us, it's like, for me, I've always been very good at, focusing on what's most important, really streamlining it, being logical about, okay, here's point A, here's point B, here's point C. These are the things that are relevant to that, and this is what we go through. So, but you rely on your lawyer to do that, or your coach, or whoever's helping you through the process. But when it's emotional, and listen, it's your kids, it's your life, it's your house. How could you not be emotional about it? It's funny. I used to have cases before a judge for child abuse and neglect cases, and this Department of Social Services lawyer on the other side of the case used to, every time when I came in representing a parent who'd had their kids taken away, every time they had an outburst, she'd be like, see, and their behavior. And I used to say to the judge, you've taken their kids away from them. How do you expect them to not be upset? How do you expect them to not be agitated or loud or crying, or what do you expect? Well, when the caseworker went to the house and tried to pull their kids out of the house, they were cursing us out. And if somebody went to your house tomorrow and tried to take your kids away, would you be cursing them out? Of course you would. Forget about whatever the behavior was that precipitated it. You just have to understand, you take people as you find them with these sorts of situations, and the emotions are really high, and you need to expect that. These are human beings. This is their life.
Yeah. Yeah, it's so hard. And someone just said asking people not to lead with emotions is totally unrealistic, especially in cases like ours.
Right.
But we know that emotion is not effective in court. I mean, you can have some emotion, but that's why you have a lawyer.
Right.
Or if you're pro se, you have to ground yourself.
I think, let's say this. I'm not saying don't lead with emotion. What I'm saying is lead with emotion to somebody who can help cut the emotion out of it and keep it only to the relevant things, because the judges won't really appreciate the emotions like your lawyer or your representative will. They need to understand your emotions to understand your plight. However, you need to also be understanding as a client that they're cutting the emotions out of it, because that's not what arguing a case in court is about. It's not about the emotions necessarily. It's about the law applied to the facts. That's what it is. And keeping it focused on that, hyper-focused, will take you much further.
Yeah. Yeah. We'll just keep repeating it.
Yeah.
Okay. So another thing, this is my last big
Sure.
question for you. When someone moves on and they get a new partner, we always, and they have children already from the marriage, what are some bad choices that people make that you see that are not helpful, either with just the kids or in court, regarding new families, blended families, new partners? I know in LA, they say that one of the bad things people do, because LA is such a high divorce rate.
Yep.
We were just there this past weekend. But they said they bring their new partner into court while they're getting the divorce.
I think one of the typical things that they do that's a poor choice is the person that they choose to bring in either too quickly or not a good choice to begin with. So, you know, because remember, once you bring that other person into your life, now everything about them can be scrutinized for your custody and visitation case. What's their criminal history? Do they have a substance abuse history? Any history of mental health? What's going on in their custody case, if anything? Were there any orders of protection? Because what you're doing is you're giving the other side a strong argument on a proverbial silver platter for them to argue if there's any, you know, kind of chinks in the armor, let's say, if there's any weaknesses, if there's anything that could possibly be argued as not being in the best interest of the kids. So I think choosing wisely, I think, is one of the most important things you can do. Choosing wisely the person you're going to date post-split or post-divorce, giving yourself time to introduce them to the kids. You don't just say, hey, I just met this person, we're all moving in, because that can create a lot of difficult wrinkles in your situation. And then certainly don't involve them. They're not the parent. While a step-parent's responsibility and place and relationship with the kids can be super important, sometimes even almost as important as a biological parent, if not more, they're not the biological parent. And you just need to make sure that that's made clear. I think in those sorts of circumstances, just make sure they're not relaying information. They're not really making major decisions. The two parents are only bio mom, bio dad. And I know some people don't like to hear that, but the reality is that's the way the court will look at it. When you go into court and you say, hey, you know, stepmom was like deciding whether, you know, and stepmom was arguing with bio mom. Hey, listen, once that starts, what's going to happen is the judge is going to say, okay, but that's stepmom, no matter what role she's earned. And believe me, step parents earn a huge role these days. Many of them are just killing it. But you're never going to put yourself in the place of the bio parent, and that could hinder your case. So calling them mom, so having them show up to court appearances, so relaying messages through them, having them, you know, utilize corporal punishment, having them, you know, make decisions on behalf of the child. Just be pumped. I would pump the brakes on that. I would be in it as a step parent and be supportive, but I wouldn't be trying to like substitute yourself or do things that look like you're trying to substitute yourself as a bio parent.
Oh, that's great advice. Like, I'm thinking, just when you started bringing that up, one of our people has an ex who is not communicating over the kids, but the new partner is. So our bio parent is communicating with ex's new partner because ex won't communicate. Our client's saying, is it better that at least I'm getting some information on the kids? And I said, I think that's probably really bad what your ex is doing.
Yeah, for sure. For sure.
Yeah. Okay. All right. So Dennis, this is it for today. I thank you for all the energy and wisdom as usual. Is there anything else, and how can people find you?
You guys can find me on, I mean, listen, just my thing at this point is just check out my DRV Law stuff. So we're rebranding our podcast as the DRV Law Show. So you can check that out anywhere you listen to your favorite podcasts. And DRV Law, the TikTok, and DRV Law, the Instagram account. So we just did recording this morning. So we're going to be releasing a bunch of new videos. So, you know, you're going to see from me logistics, you know, nuts and bolts of things, because I think, you know, there's so much talked about the law and the split. And I think there's not enough talked about the logistics behind it. Because like I said, if you think you're going to worry about how strong your petition is drafted, and you're going to draft it, you're going to go before a court, and you're going to make all your arguments, and you got your 50 pages of emotional things that you're going to talk about and argue, and the judge is going to believe you, and everything's going to rule in your favor, not going to happen.
Right.
Not going to happen.
That's what we call the harsh New York reality check, right, Dennis?
Right. So start
better to know now.
Start thinking about what are the logistical things, the nuts and bolts things you can do that's not necessarily solely hinged on the court system to improve your situation or maintain it, or just deal with somebody who is an asshole and you're not going to change them. So
yeah,
I can say that on this, right? This is Instagram.
You can say it.
Okay.
You know you can. All right. Well, thank you so much, Dennis. It was great catching up with you.
Good being on. I'll see you again soon.
All right.
Take care.
Talk soon. Bye.